Judge beg Nnamdi Kanu make e find lawyer. Court drama for Abuja. Dis na CenokMedia, the channel wey dey report the news and dey make am simple for everybody to understand. We dey thank una when e dey view us. Abeg subscribe if you never do so. Put on your notification button. E go tell you as we drop update. Like, comment and share the video. My people, una welcome once again to CenokMedia, where we dey always bring una the full gist, not just headlines. Today on sweet and serious at the same time. Courtroom drama wey shock everybody as Judge James Omotosho beg Nnamdi Kanu in the name of God Almighty make e consult lawyers before e go continue in case. Yes, na true gist be dis, not be social media rumor. The thing happen on Monday for Federal High Court Abuja inside Kanu terrorism trial. The same case wey don drag since 2015 with arrest, bail, rearrest for Kenya, appeal court wahala, Supreme Court reversal, the whole journey. Monday episode be one of the most dramatic we don see in recent time. As court sit, Kanu no come with any lawyer. The man sack im legal team before now and say he go defend himself. But as case start, something happen wey nobody expect. Instead of opening defense, Kanu stand up talk say he don study the file, and as far as he dey concerned, there's actually no charge against me. The judge, Justice Omotosho, just pause small, look the man for eye, and talk calmly. I am begging you in the name of God Almighty, consult properly before you proceed. This not be economics. This na criminal prosecution. That one shocked the courtroom. You fit feel the tension. The judge constantly talk say, I know you are educated, but you are not a lawyer. Please, my brother, make adequate consultation. He come beg Kanu with respect, like senior dey advise junior, because he know wetin he dey talk. This kind case na criminal trial, not be ordinary argument where grammar fit win. One wrong step and the whole defense fit collapse like building without foundation. Now make we reason am deeper. Why this plea dey important? For criminal matter, defendant get three ways to handle your own side. One, you open oral defense, call witnesses, talk your story, try scatter prosecution evidence. Two, you fit choose to rely on prosecution own case, say dem never prove anything, then file written address instead. Or three, you go make something dem dey call no case submission, telling court say there is no valid case to answer. Kanu be like say he combine the last two. He tell court say prosecution no get charge, so he no need to open any defense. But the judge no wan just rush am. He try make Kanu understand say if you miss your chance to defend yourself, no be small matter. Court go rely on evidence wey prosecution don already drop. The judge constantly agree to give am time to file written address, about 7 days, so he go fit put the arguments down neatly. But this thing raise big talk because earlier, Kanu don already list 23 witnesses wey he say he go call. Court even reserve 5 seats for them, label am summoned witness. That one mean say court dey fully ready for defense to start. Yet the same day, defendant say no need. That twist alone show you say plenty dey under this case. Now make we look am from another side, the health and fitness of Kanu to represent himself. You remember say few weeks ago, news circulate say medical panel dey review im condition inside DSS custody. If true, e raise question whether person wey dey under such physical or mental pressure fit properly handle self-representation. Because for serious trial like this, energy and concentration matter. If health no balance, e fit affect performance. Another fresh corner to check those 23 witnesses wey Kanu list. Who dem be? Where dem dey? Some reports talk say 2 of them even foreigners. If na so, wetin be the process to bring them to testify? They get diplomatic clearance? Court send summons go outside Nigeria? Those details fit later decide whether evidence go stand or e go fall for technical reason. Now make we go wider, the international angle. You know say this case not be local matter alone. Since the 2021 arrest for Kenya and the controversial transfer wey bring Kanu back to Nigeria, many international observers dey watch. Human rights groups, foreign embassies, even legal bodies for UK and US dey monitor how this case go end. Some dey argue say the arrest process break international law, while government insist say e follow due process. That tension still dey underneath every courtroom move. So when judge beg am to seek proper counsel, e not just dey talk as Nigerian judge, e dey speak as person wey know say dis case na global spotlight on Nigerian legal system. Now, politically, e still get ripple because for the southeast, every update from Kanu case dey carry emotional weight. If e sneeze for court, headlines go blow everywhere. Some supporters fit interpret the judge plea as empathy, others fit see am as pressure. Either way, tension dey. And with 2027 election heat already building, the behavior of groups like IPOB fit affect turnout and peace for that region. As for the federal government side, their counsel, Chief Adegboyega Awomolo, SAN, come prepared for defense to open. He announced appearance, ready for cross-examination and witness phase. So when Kanu suddenly say he not go open defense, e be like curveball. But Awomolo no argue. He just remind court say the business of the day is for the defendant to open his defense. So prosecution now just dey wait for written address. Make we check the legal consequences of this move. If defendant rely only on written argument and the prosecution evidence remain unchallenged, court fit easily say prosecution don prove their case. That na why judge warn, consult experts, because cross-examination na where defense dey usually dismantle government points. But Kanu maybe get strategy. Maybe he wan use law to show say the whole case not valid. Maybe he dey hope the same no-case approach go work like before when appeal court wan quash the trial. Or maybe na silent protest saying, I no recognize this court jurisdiction. Any of these motives fit dey behind im calm refusal. Meanwhile, for legal community, this case don turn hot topic again. Lawyers dey argue for X, wey be former Twitter, say should a judge beg a defendant? Some say yes, that's human compassion. Others say judge suppose just record warning and move on. But anybody wey understand criminal law know say judge not suppose allow defendant walk blind into trap. The begging na professional caution. From here, e get two key things wey go happen next. Kanu go submit written address within days. Prosecution go file reply. After that, court go fix date for judgment or ruling, depending on wetin the defense file contain. Make we not forget, say na same Justice Omotosho handle earlier parts of this case wey involve serious security issues. So every adjournment dey heavy. DSS, police, journalists, lawyers, everybody dey alert. Now make we talk about the societal side. The way this trial dey handled fit shape how people for Southeast trust federal institutions. If dem feel say the process fair, e go calm nerves. But if dem see am as one-sided, unrest fit follow. That na why transparency matter now pass before. Before I close, make we recap the main line of the story. Court sit for Abuja on Monday. Nnamdi Kanu refused to open defense, say there is no charge. Judge Omotosho beg am, in the name of God Almighty, consult properly. Court grant adjournment, give short time to file written address. The earlier list of 23 witnesses remain hanging. Now, my people, see wetin wey be the real wahala inside the calm talk. I mean, the deeper challenge. The next move go determine plenty things. Whether court go still entertain witnesses, whether prosecution evidence go stand untouched, and whether another appeal go enter soon. As we dey talk now, tension not dey only for courtroom. Even streets dey watch like say na football final. Supporters dey hope, critics dey talk law, and analysts dey measure every sentence. So now the big question for una wey dey watch, should anybody represent himself for criminal trial, or should court force legal counsel once the charge heavy? Tell me your view for comment section.